Well, good morning from St. Bart's in Midtown Manhattan. My name is Peter Thompson. I serve as the vicar here, and whether you're joining us here in person on Park Avenue or joining us online at stbarts.org, it's my joy and delight to welcome you to the forum, where each week we have sacred conversations about the things that matter. And today, not too long after the Supreme Court announced the verdicts on the final cases for the year, we're talking about religious freedom, a concept that has become very important in a number of hot-button legal cases. And to discuss this with us, we are honored to have Liz Reiner Platt, who is the director of the Law, Rights, and Religion Project at Columbia Law School. Liz, thank you so much for being with us on this hot midsummer morning.
Thank you. Delighted to be here. So, yes, my name is Liz Reiner Platt. I direct the Law, Rights, and Religion Project. We are a law and policy center based at Columbia Law School that works on religious liberty, pluralism, and with a particular focus on gender, the intersection of religious liberty and gender justice issues. So we do original research, write reports, write amicus or friend of the court briefs, and kind of otherwise participate in this very lively right now public discussion over religious liberty rights in the law. So, as you probably all know, I'm here to talk to you about progressive religious liberty and what that looks like and means to me. But I think I need to step back with a little bit of context and just start, at least, by talking about what religious liberty too often means today, and about, frankly, the Christian right and the decades-long campaign that has been going on to advance a very particular public meaning of religious liberty. And then I will step back and talk about some of the work that I do to advance kind of a more pluralistic, I think, and affirmative vision of this fundamental right. So first, how do we see the term religious liberty being used today? So I think probably, as many of you know, just from being active citizens, reading the news, when we hear about religious liberty in an article or in a law or a lawsuit, it's almost always going to be these days about one of a very narrow set of issues, and really that is sex, gender, and reproduction. And this very kind of confined vision of what religious liberty means and what issues are important for religious liberty, I think, has been adopted so sort of widely in the public discourse that we can see, example here up on my slide of our former Attorney General William Barr, who has, engaged in public screeds against atheism and atheists, who supported the Muslim ban, nevertheless being called a robust advocate for religious liberty in an article by a veteran reporter on the front page of the Times. So how did this happen? How did William Barr become the face of religious liberty? There are no doubt many factors, but I think one of the big ones is really an issue of resources. Christian right legal and political organizations have been investing, have been, for those of you who can't tell, I'm very pregnant, and so breathing a little heavier than normal, so I apologize for those sounds. But they've been investing massive amounts of money, resources, organizations, and labor into capturing this public idea of religious liberty. So to give you an example of what that looks like, in a study we did a couple years ago, we found that in 2018, Christian conservative law and policy nonprofits working on religious liberty issues, as they define them, received about 7 times the revenue, held 4 times the assets, and employed 3 times as many people as organizations from other religious and political backgrounds working on religious liberty issues. And that disparity in resources is actually most likely a pretty big underestimate of the disparity, because when you look at what those organizations actually are, the conservative ones are much, as I'll talk about later, are much more highly focused on religious liberty issues. The more progressive ones are working typically on a range of different issues. So So what does that kind of disparity in investment actually look like on the ground, being operationalized? Well, it looks like an enormous disparity in the amount of work that gets done in terms of litigation, policy and media campaigns. So this gives you kind of a little bit of a sense of just the scale of litigation that's happening right now from, again, these Christian right legal organizations. Again, these lawsuits are all being framed as religious liberty lawsuits, but they're all about essentially opposition to contraception and LGBTQ rights. So up here, this list includes claims by teachers who claim a religious right to misgender their students, their transgender students, employees at for-profit corporations who are saying they have a religious right to not hire or to fire gay employees. And to be clear, I stopped on this slide when I ran out of the room. I could have probably a dozen more slides of names with these kinds of cases. So when you think about a progressive vision of religious liberty, or even not to politicize it, but just anything other than this kind of Christian right vision of religious liberty, there's not the same scale whatsoever. And then there's also, as kind of I hinted at earlier, a really significant disparity in the focus and the framing of religious liberty. So conservative groups frame their work very explicitly as we are fighting for religious liberty. They use the word a lot, and they focus often very narrowly on this issue with maybe some kind of vaguely related issues, like, they'll just anti-abortion work more generally, for example. Instead, the more progressive groups often don't actually even use the term religious liberty at all. They'll talk about things like church-state separation, or they'll talk about religious diversity or pluralism, but they're just not really using really embracing the term religious liberty frequently. And again, as I mentioned, a lot of the organizations that are doing work at all on the issue are also working on a dozen other issues: racial justice, economic justice, gender justice, immigration, et cetera, which is certainly not a critique, but again, just an explanation of why we're seeing what we're seeing. So I think that difference in kind of focus and framing can be really clearly seen in this slide up here, because this shows how conservative religious denominations, many of them have entire centers that are explicitly dedicated to religious liberty. You can see religious liberty right in the name of, these are all denominational kind of centers that engage in political advocacy work. I would not be able to make this slide for kind of more liberal or progressive or even moderate denominations, because even though many of them have taken, particular stances on particular religious liberty issues or have occasionally filed a brief or what have you, it's nowhere near the same kind of priority or engagement level. And then finally, the conservative legal movement just has a lot of different groups working in all sorts of different ways on advancing this vision of religious liberty. So it includes law and policy organizations, large social and fraternal groups like even the Knights of Columbus, which I know is not, there are a lot of people that are in the Knights of Columbus. I don't mean to say one way or the other, but they're very politically, they encourage their membership to be engaged in political issues on these topics. Media outlets, publishing houses, grant makers, conservative Christian colleges that often have institutes that are training students on religious liberty litigation tactics and things like that, and engagement in politics. So again, these groups are all kind of working in all sorts of different ways to advance this kind of particular vision of religious liberty. So in sum, the Christian right is extremely well-funded, very, very highly focused on this issue of their kind of conception of religious liberty. It includes a very large number and variety of different organizations. And so it should be no surprise to us that it's been extraordinarily successful. An over 15-year winning streak before the Supreme Court in a handful of cases, even with the support of, who we think of typically more liberal justices like Elena Kagan and Stephen Breyer. dozens of bills being passed that, again, claim to protect religious liberty, but really protect people who oppose contraception and LGBTQ rights, often with no kind of protections for the reverse communities, no protections for example, someone who wants to provide comprehensive health care because of their religious beliefs. And a very successful, I think, capturing of the public media narrative on what these rights mean and look like and how they should be protected. But of course, the name of my talk is not the Christian right. I didn't come here to talk to you about that, but I do think it's important to start there. But I came to talk about our work to try to change this conversation on religious liberty issues, and the work that we've been doing to sort of develop and think through and advance what a different vision of what religious liberty looks like. So I'm going to be turning to that now, relying primarily on two reports that my organization has issued over the past handful of years. So I'm going to start with a 2019 report called Whose Faith Matters? The Fight for Religious Liberty Beyond the Christian Right. And this is an organization, a report that gives a really sweeping overview of religious liberty lawsuits that have been filed by people of faith associated with different social justice and humanitarian movements. And I know I keep relying on these super politically charged terms. I wish there was a better way to do it, because I know that, even William Barber, think of this titan we think of him as like a titan of the Christian left, and he hates that term. So I kind of wish there was something better than that, but I am going to be relying on these political terms just out of ease to communicate the kinds of people and communities I'm talking about. So anyway, the aim of this report was to show that conservatives don't have a monopoly on religion or religious exercise, but also, frankly, to show how a lot of these lawsuits that I'm going to be highlighting and a lot of the advocacy being done has typically been a lot less organized, a lot less funded, and frankly, often a lot less successful before the courts. So the report, again, outlines lawsuits that have been brought arguing for religious liberty right to, for example, litigation brought by anti-war protesters, by Native American groups seeking to protect sacred sites from having roads or pipelines built in them, clergy members who sought a religious liberty right to perform same-sex marriages back when that was illegal in some states, and a whole lot of other cases brought kind of by different religious groups and issues. So you may recognize a few famous faces on this slide. They're the Berrigan brothers over there, who brought some anti-war cases, and so we took a historical approach up to cases being brought today. And so I'll take a moment to highlight a few of kind of the most notable ones that I think, or variety that I think will be interesting to you. Depicted here are volunteers with the faith-based organization No More Deaths in Arizona. They were federally prosecuted for leaving out food and water in the desert for migrants who are crossing the border in areas where they have found bones, essentially, of people who have died of dehydration crossing the border. So they were federally prosecuted, and they raised a defense under a federal law called the Religious Freedom Restoration Act, or RFRA. That was the law that was at issue in the Hobby Lobby contraceptive case, for those of you who follow the Supreme Court. And they explained that their activities were a form of protected religious exercise, and therefore it was a violation to prosecute them for that activity. And they actually won some of their claims before a federal district court. For a few years now, a multi-faith organization in Philadelphia called Safe House has been working to try and open a safe injection site for people who use drugs, so that there's someone available on site to call for medical help if, in the case of an accidental overdose. So they brought a suit several years ago arguing that to the extent the Controlled Substance Act would prevent them from opening that safe injection site, that would violate their religious liberty rights. And that lawsuit has been going on for many years. It's still going on. In 2018, a group of 7 Catholics affiliated with the Plowshares movement, including actually Dorothy Day's granddaughter, which is kind of interesting, were arrested for breaking into a U.S. nuclear military facility and performing a religious ceremony that included pouring out vials of their own blood on nuclear weapons. They, again, were prosecuted and brought a religious liberty defense. And while the court found that their ability to practice their religion was being burdened by the prosecution, they, understandably, I would say, found that there was nevertheless a sufficiently compelling interest in prosecuting them because the government had an interest in the safety of its nuclear military facilities. So they did end up serving prison time, but the Plowshares movement has brought a few religious liberty cases over the years. And then there have been several cases. These are three of the plaintiffs in three different suits, but there have been more, brought by Muslims who have experienced targeted surveillance and harassment, including things like questioning about their religious beliefs and practices at the border, unwarranted surveillance of mosques and religious communities and student groups, and of course, challenges to the President Trump's travel ban several years ago. So these suits all basically argued that these various policies and practices of targeting and investigating Muslims because of their religion and their religious background chilled religious exercise and was a violation of religious liberty. These lawsuits have basically always failed. I don't know of a case that has found for the religious rights in these cases. So, and then since the 1970s, there have been many challenges to a wide variety of abortion restrictions, legal abortion restrictions based on the right to religious liberty. In the pre-Roe era, there were a handful of suits brought by members of the Clergy Consultation Service on Abortion, which was a national network of clergy members who helped refer women to safe, vetted, illegal abortion providers in the United States, as well as helped people go get abroad for abortion care. And then more recently, there have been a handful, in the wake of Dobbs, we've seen a handful of new litigation being brought, challenging abortion bans on religious grounds. Suits filed in Florida, Kentucky, Utah, Wyoming, Indiana, Idaho, and Missouri. And this issue, I'll just say, is like a particular area of interest for me personally. I've been following all these suits quite closely. We actually did a whole report specifically dedicated to these religious right to abortion suits, which we released last August. So I'm happy to answer more during Q&A if people have any special interest in these suits in particular. I'll also just briefly note that we, as an organization, have actually filed some amicus or friend of the court briefs in several of the cases that I just discussed. And our approach in these cases is actually not to file on behalf of either party, but rather, not to say these people deserve an exemption or they don't deserve an exemption, but rather to kind of lay out the landscape of the law and say that to the extent that we are providing these extremely robust religious liberty protections to people who are objecting to contraception, et cetera, we need to be applying the same standards and the same tests and the same seriousness to these people who look a little different from those folks. Because I think it's really easy for judges to find ways to kind of dismiss these cases, frankly, because they don't see it as really religious, they see it as more political, or it just doesn't hit them the same way. And so our tactic is basically to say, you can't pick and choose what kind of religious beliefs you think are worthy of legal protection. Again, here are the standards, and these need to be applied just as rigorously to these claimants as we've seen them being applied to other folks. And one of the reasons that I'll say that I think that tactic we feel like it's helpful and necessary, is that a lot of the attorneys handling the cases that I just described aren't coming from big, specialized religious liberty expert law firms the way almost all of the Christian right cases are, right? They're all coming from these cases with attorneys who do nothing but litigate religious liberty cases and have a huge amount of expertise. Instead, they're largely being brought by kind of individual private, public defenders or litigators or whatever across the country who see this as a potentially helpful claim for their client, but don't have that kind of specialized expertise. And again, this kind of just goes back to that issue of disparities that I started with. So those were some of the more kind of specific examples of what progressive religious liberty can look like in practice. But I also wanted to end by kind of zooming out a little bit to think about the larger principles at play. So in 2020, after the Whose Faith Matters report, we used that Whose Faith Matters report to issue something else called All Faiths and None, which we partnered with Auburn Seminary to write. And what this report does is articulates 6 kind of overarching principles for how we think religious liberty should be protected across the board. And those 6 principles we came up with were kind of distilled from reading a lot of cases over the years, many, many, many cases, but also from a series of private convenings that we held with a large variety of stakeholders to kind of talk about, okay, we talk a lot about what religious liberty shouldn't do and shouldn't look like. What do we think it should look like, right? It is a fundamental right. It's in our Constitution. It's important. So what do we want it actually to mean instead of just focusing constantly on what we don't want it to mean? Okay, so these are what we came up with, and I'll go over them pretty quickly, I hope, and then we'll have, I think, plenty of time for questions. So the first one is that religious liberty has to be neutral, and I kind of talked a little bit about that already when I was talking about our strategy with amicus briefs. So in other words, the government shouldn't single out particular theological communities or beliefs, either for special protection or for special persecution. It should be remaining neutral when it comes to issues of religion and theology. And so policies we singled out as violating this kind of neutrality principle include, any laws targeting Muslims, especially in the areas of immigration, criminal justice, and counterterrorism, as well as any laws that really provide special rights only to people who hold particular religious beliefs about an issue. So for example, I kind of talked a little bit about this earlier, there are a lot of laws out there that provide, that say if you are working in a hospital that allows abortion but you oppose it, you have a right to refuse. But if it's the opposite, if you work at a hospital that bans abortion and you feel like a religious obligation to provide comprehensive care, you don't have that right. That's a structurally imbalanced law. It provides protection only for one particular theological belief, and we said that this violates the neutrality principle. Oops, oh, it's all on one, I forgot. Okay, the second one is non-coercive. So the whole point of having religious liberty protections is to allow everyone to follow their own conscience, right? Instead of being coerced to follow the religious beliefs either of the government, right, or of your neighbor, of your fellow citizen. So this kind of non-coercive principle is obviously violated if you're talking about, a government actor like a teacher or a judge forcing you to say a prayer or saying you have to go to jail or go to this religious programming, which still occasionally happens. But the principle can also be violated when the government effectively conscripts you into bearing the cost of someone else's religious beliefs. It's kind of a less direct version of, I think, the same problem. So if I am forced to give up one of my really important legal rights, like my legal right to engage in the public marketplace or to work in a non-discriminatory workplace, if I'm forced to give up that right to accommodate someone else's religious beliefs, to me, this again violates this idea of non-coercion. The government is telling me I have to give up my rights because of someone else's religious beliefs. The third right is non-discriminatory. So we constantly are seeing this framing of religious liberty versus civil rights. And we've done a lot of work along with religious minority organizations from a range of traditions to say, actually, particularly for anyone really, but particularly if you're a religious minority, civil rights law is what allows you to have religious liberty. Because if you feel like you can't get a job because you're wearing a hijab or a yarmulke, that's not protective of religious liberty. It might protect a few people who are small business owners who don't want to serve people in a certain way, but it's really bad for religious pluralism, and it's really bad for the work that we've done over the past 50 years to kind of break down religious segregation in the marketplace and in employment. So we did a couple amicus briefs that essentially make this point. In the Masterpiece Cake Shop case, the case involving the baker who don't want to sell cake to the same-sex couple, and the 303 Creative case that Peter mentioned up top. All right, the fourth principle is that religious liberty is not absolute. This one, to me, should kind of be a no-brainer. There's no absolute constitutional right. The kind of example that law professors love to give in class is there's no right to engage in human sacrifice, although now with the COVID cases, I heard one person say there is a right to human sacrifice if it's actuarial. So we can, I don't know, we can go there during Q&A if you want. But when there are other really important government interests or constitutional rights at stake, we have to look for a balance. And our court actually knows this, and it does deny religious liberty claims all the time, but as you might imagine, more so for people who are already coming from sort of disfavored communities. So courts happy to deny religious liberty cases brought by people in prison, for example. And then the last one is that, second to last one is that religious liberty must be democratic. So rather than trying to protect religious liberty for everyone, or in the case of a direct conflict, because sometimes that happens, awarding some amount of leeway or preference to people with kind of less political power in our democratic system, a lot of our religious exemptions sort of do the opposite. They tend to prefer the religious rights of corporations, massive institutions like huge hospital conglomerates, et cetera. When we came, we're talking through all of these kind of complicated issues, we figured it would be better to take special care to protect the religious beliefs of those with the least power and influence, workers, consumers, individuals, for the most part. This can get complicated, but again, these are just kind of general guidelines and principles. So we just think we should be very wary of religion laws that, I think that, again, of those who already are kind of overrepresented in our democratic process. And that's particularly true, I think, when we think about religious institutions that are seeking religious exemptions, that seek to really strip kind of bargaining power and other forms of social and political power from others. So, for example, there's been a trend of increasingly seeking exemptions, large institutions trying to seek exemptions from the right to recognize unions, for example. That already happens in a lot of religious colleges and universities. We're now seeing attempts in the medical field of religious institutions trying to say we have a religious right not to respect the collective bargaining of our workers. And then the last one is that religious liberty has to be pluralistic. And this kind of takes me all the way back to the beginning, right? Religious liberty doesn't mean protections for one particular community, it means protections for all of us, and it goes to this larger issue of really doing our best not to conflate religious liberty with very conservative Christianity, even unintentionally. And we think it's really important when we're thinking about religious liberty to place front and center and to prioritize the voices and the experience of people who are often now kind of in the margins of these conversations. So again, non-Christians, the rising group of nuns, N-O-N-E, people who might be religious in their own way but are unaffiliated, religious communities of color, who again are often not represented in these conversations at all, and really putting a focus on their kind of experiences and needs. And I also think this means wholeheartedly rejecting a religion versus LGBTQ rights or religion versus reproductive rights framework that, again, we see so often, because first of all, those things are there are many LGBTQ Christians. There are many, these are not fundamentally in conflict for all people. But also, I think it erases the fact that in a lot of these legal disputes, there are often both secular and religious interests on both sides. And we really don't think of it that way. We don't think about, for example, whether that gay couple seeking a wedding cake are doing so because they have a religious commitment to go get married and to have the celebration. So there can be, it's often, I think it oversimplifies the kind of both religious and secular interests that are going on in these cases. And the right to make your own religious and moral choices about your sexual and your family life without fear of losing your home, losing your job. It's a secular equality right, but again, I've kind of talked about this already. It's also a right. It's also a freedom of conscience right. It's a right to live out your own values, and both religious, including your religious values. And then I'll just note that with this All Faiths and None report, we also did an accompanying media guide for journalists to help them kind of think a little bit more critically about what religious liberty means when they're, when they're covering these lawsuits, or when a policymaker comes to them and says, I've got this great new bill on religious liberty, let's take a minute and think about, okay, well, what does it actually do, and what does it mean, and who's it going to protect, and who's it not going to protect? If any media folks are in the room, please look it up and distribute it if you're interested. All right, so thank you very much. This is my email address if anyone wants to get in touch, and I think we're moving to Q&A.
Excellent. Well, thank you so much, Liz. We have plenty of time for questions for Liz. If you're here in the room, Suzanne Vorster has some question cards, which she will distribute to you. Just raise your hand and she'll come around to you. And then you'll fill those out and hand it back to her. If you're joining us online, you can drop your questions into the live chat on YouTube, the comment section on Facebook, or you can email me, pthompson@stbarts.org, pthompson@stbarts.org. Email also works if you're here in the room. I wonder if we can take a step back for a moment, and if you can just remind us, what does the Constitution actually say about religious liberty, at least as most folks have interpreted it today?
So the blessing and the curse of the Constitution is there's not a huge amount to go off of. Congress must make, oh God, now you're going to embarrass me in terms of the exact wording. Basically, Congress cannot infringe on the free exercise of religion. It's basically all it says. It doesn't say what free exercise of religion means. It doesn't say, I would say I'm not like an originalist, but the founders didn't give us a whole lot of guidance in terms of, I think they realized that was not absolute. Again, the classic no right to human sacrifice. But in terms of sort of putting meat on the bones, in terms of what are the limits of that right, it doesn't give us a whole lot. And then there's also, of course, the Establishment Clause, which I didn't really talk about very much explicitly. No right to burden free exercise of religion, or to establish a religion also. The Establishment Clause is basically a shell of what it has been in the past. Last term, the Supreme Court issued a case called Kennedy v. Bremerton, which involved the kind of praying football coach case. There's a public school football coach who was praying in the middle of the field immediately after games, sometimes surrounded by students. And the interesting thing about that is that sounds like a Establishment Clause problem. That sounds like a church-state problem. But actually, it was brought as a free exercise case, and that's what's increasingly happening, is that he was asked to pray a little bit more privately. He refused. He eventually, after a long time, was fired. And then he, instead of there being any sort of Establishment Clause argument, he brought a free exercise argument saying, my religious liberty was violated because I was not allowed to engage in this very public prayer during a public school event in the middle of the field. And the court, in the course of that decision, they found for the coach, and in the course of that decision kind of totally upended the Establishment Clause doctrine to say that it's now based on kind of history and tradition. What does that mean? What does that look like in practice? We kind of have to wait and see.
Can you talk a little bit more about where the current Supreme Court is on these issues based on what recent cases have indicated?
Yeah, so I think, again, not to spend too much time kind of complaining about the media, because they do great work and it's a very, very hard job, but I think we see a lot of articles about like this court is so protective of religion, it's so protective of religious liberty, and that's really only a half-truth, because to me the clearest example is if you look at, for example, the Masterpiece Cake Shop case versus the Trump v. Hawaii case. So those are two cases that happened a couple weeks apart. Masterpiece Cake Shop, the court, this is again the Baker case, they do a very searching review of the record, look at like everything involved in the case, and issue this opinion that says, actually, because of two comments that were made by one member of a panel at the very, very beginning of this lawsuit, we're going to find that this baker's constitutional rights were violated because he was the victim of religious discrimination. There was one commissioner that said, oh, it's terrible to use religion as an excuse to discriminate. That's happened during slavery and during the Holocaust, and it's terrible. Because of essentially that comment, they found that he had been the victim of religious discrimination, and they threw out the case against him for discrimination against the same-sex couple that had been denied service in that case. 2 weeks later, we have the Muslim ban case. I think everyone's aware of the comments that were made by the president leading up to that case, and we got to prevent Muslims from coming in the country until we know what's going on, and all of the kind of you never get a case. No lawyer would ever gets a case with so much public evidence of animus against a group. I mean, usually you really need to do a lot of work to try to show discrimination. They didn't have to do a lot of work in this case. It was out there, and yet the court did not go there and upheld the ban, despite. So again, like Jack Phillips was the victim of discrimination because of this one comment. Muslims were not the victim of discrimination in the Muslim ban case. So I feel like I'm giving you much more than you asked for, but I just think that's the example of like, this is not necessarily a pro-religion or a pro-religious liberty case. It's a conservative court. It's a conservative court, and the conservatives, that's Christian conservatives, and it's also conservatives in general, are the ones who are winning.
You were quoted in a New York Times article earlier this week.
I was.
And that article mentions that organizations like the Episcopal Church, which provide kind of arguments and examples of religious groups for whom abortion rights are important, can be helpful in these cases. Can you talk, if you know anything about the Episcopal Church specifically, but what can the role be of more progressive denominations and other religious institutions in these cases?
Yeah, well, I'll say, I don't know that we are going to convince the Supreme Court to take a different approach, but I think it's a long-term process, and I think there are a lot of battles that have to be won outside the courtroom. And I think, again, because there's so much history that has been lost because the Christian right has just been the loudest voice on the room of what religion means for so long. And so I think, and despite the fact that I think religious liberty law has been so warped in favor of particular religious communities, if you look at polling, people still support religious liberty, which is a good thing. I mean, they should. But it's about who gets to define what that means. And so I think speaking up over the long term and showing the range of religious beliefs on these issues, and to show that you can support religious liberty and robust religious liberty rights without supporting exemptions that say that you can turn people away who you don't like. It just gives people kind of a new way to think about these rights. Because I think there's been creep. I mean, I think now if you're not super engaged in these issues, it's really easy to say like, oh, well, this is what religious liberty means. And maybe I don't love it, or maybe I don't, but to accept that the kind of narratives and meanings for what these rights look like in a way that's not helpful. Is that okay?
And sort of related to that, someone brings up that we don't really have public discussion and debate about the substance of religious issues, and wonders if there's a way for us to have public discussion about religious topics that might help us kind of challenge those narratives.
Yeah, so the sixth principle report, actually I almost wish my kind of colleague, Dr. Keisha McKenzie, who worked on me from Auburn on that report, she actually made it into kind of a learning module that she then took to, I'm trying to remember if it was Arizona or Utah, but she was in a room with not super conservative, but maybe like moderate to moderate right religious groups and LGBTQ activists who were trying to hash out what a law that would protect LGBTQ rights should look like in that state, and the scope of do we want, like, trying to figure out that balance, right? That balance between the rights of these conservative religious institutions and the LGBTQ community. And she actually used those six principles as a kind of learning module to say, well, which of these do you feel like is most important? Kind of as a values clarification, right? To think, where's everyone coming from in where they see what this principle looks like and means for them. And so I think, I would love to, if you want me to come back and do something to engage in that kind of public conversation. But yeah, I think there's a lot more kind of discussion, engagement, and values clarification that can happen. And I think there's a hesitation to be seen as too political, which on the one hand I understand, and on the other hand, life is political, right? Yeah, these are important issues, and we kind of, I think it is important that both progressive political movements become more comfortable with religion, and maybe perhaps religious groups become more comfortable talking about these like sensitive political issues.
Can you talk a little bit more about the alliances that can form around these issues? Are there any specific issues that, say, liberal and conservatives pertaining to religious liberty that liberals and conservatives might agree on and work together on? And similarly, is there cooperation happening on any of these issues across faith traditions, where religious liberty is important to, say, Jews and Christians and Muslims?
Well, definitely the latter. I mean, we... the two amicus briefs, for example, I mentioned that we did in 303 Creative and Masterpiece Cake Shop were on behalf of a really wide range of religious groups: Christian, Jewish, Muslim, Hindu, Sikh, Native American. I was actually really proud of the kind of coalition we built around that. In terms of the former, I think there are certain cases that come to mind as operating not quite as intensely political of a space. So folks might have heard of, for example, the Groff opinion from this past term. It was issued the day before the 303 Creative case. And that was a case involving the rights of religious workers as opposed to religious employers. And the kind of standard under civil rights law previously had been that you have a right to a religious workplace accommodation, like wanting to wear a hijab or wanting breaks to pray, or only to the extent that it is a de minimis burden on your employer, which is a pretty low bar. And that standard was challenged, and it was overturned in a unanimous Supreme Court decision. And there were a lot of organizations that actually signed our brief against the kind of accommodation in Masterpiece Cake Shop and 303 Creative, that signed a brief in favor of the higher standard in the Groff case. So you might think that you're either against religious accommodations or you're for religious accommodations, but there were a lot of groups that kind of see the nuance there and say, It's very different to ask for a religious accommodation to be able to turn away a customer than it is to say, I need to be able to take off time for a Yom Kippur service without getting fired. So yeah, I would say there were still folks who were, I think I would say like the church, very strict church-state separationist groups were not crazy about Groff and were on the other side of that case, but there was certainly more consensus around a case like that.
One person asks specifically about the right-wing concern over contraception. Do you know where that comes from and what that's all about?
Well, that might be, that's more of a theological question, I think, than a law question.
Is it mostly a Roman Catholic concern?
Not anymore, I don't think. I mean, I will say I used to work at a Planned Parenthood clinic. That was my first job out before law school. It was my first job out of college. And we would get protesters with signs that said, "The pill kills." Which is always a little confusing on a scientific level, but that does, I don't know. Yeah, I think, I mean, even opposition to abortion, like it used to be thought of as just a Roman Catholic thing, and you know, there have been a lot of articles and kind of famously rehashing the fact that in the immediate aftermath of Roe v. Wade, the Southern Baptist Convention issued a statement supporting the Roe v. Wade decision and saying this is a good thing for, you know, like women in crisis. And we've obviously seen very much a 180 there. And so there's been a real, I mean, a religious historian could tell you all this much more, you know, effectively than I could, but I think there's been a real political merging between these groups that used to be quite opposed and like fight each other, but there's been a real political merging between the Roman Catholic Church and conservative Protestant denominations, where abortion rights and now increasingly contraception is kind of become kind of this universally motivating political issue, even when there's not necessarily the kind of actual theological support for it going back very long.
Given the Establishment Clause, why is Christmas a federal holiday?
I know it's not the hill I'm going to die on personally, but you know, I think a couple years ago the court held that a gigantic 40-foot cross on federal land was somehow not a religious symbol. I mean, like, how do you explain that? I think the old test was like, is there a non-religious reason for this? And I think to me, it's not a crazy thing to say, you know, a huge percentage of our population doesn't want to work on Christmas, so you get Christmas off. And it's not because we're trying to promote the birth of Jesus Christ, it's because, you know, it's kind of silly to force everyone to take a day off on this day when everyone, you know, 90% of people want to be home with their families. So again, I think you can make a secular argument for having Christmas off. That said, I mean, I think that's why, to me, I mean, I work with like atheist groups and groups that are very much like, it is normatively unfair for a religious person to have a right that a secular person doesn't have. Like, you know, if you want a right to wear a hijab in prison, fight for the right to change the dress code so that everyone can wear a scarf in prison. I don't want to mistake. I mean, I think there's some people that take that very, very hardline approach that it is normally exemptions de facto normatively unfair. I wouldn't go that far because I think, to me, at their best, a religious exemption is meant to take care of those kind of those sort of ways in which Christianity is baked into our law, right? So everyone gets Christmas off. It was just another day when I was growing up. It wasn't, but that means I shouldn't be punished for taking off Yom Kippur, right? So, even if that's like a special right that I get, that, and you could say like, well, I'm a secular person and I have other days that are really important, like I want to take off for my brother's wedding. Why should I be punished? Why should I have to take off a day for that and you get Yom Kippur off? you know, I get it, but to me, it's more of like a substantive equality. It's saying we have these ways in which, you know, we do kind of have this Christian nation in certain ways, and so it's a way to kind of even the playing field, not actually to put religion above everything else. It's a way to kind of make sure that religious minorities are not, you know, suffering because of these kind of practices in the way our government works.
And we do have to end now, but I'll sneak one final thing
Sure.
in, which is in a similar vein. How do we make sense of prayer on civic occasions or in the halls
Yeah.
of Congress and at state legislatures at the beginning of sessions?
Yeah.
How should we be thinking about that?
So I would point you to, there's a case called Town of Greece v. Galloway from 2014, I want to say, that talked about that. It was Greece, New York, started with a public prayer, and it was entirely Christian. Every single speaker was Christian. And so a couple Jewish people and I think maybe like a secular person sued. And what the court said was that as long as it was sort of available for any religious speaker to come speak, then it didn't matter that in practice every single one was Christian. And talked about this kind of, we have this long history, again, history and tradition, although it was before that became the New Test, but it was like this history and tradition of prayer, and it's to, you know, take account of the seriousness of the occasion, and it's for the benefit of the legislators. It's not something I agree with, and I would say that if folks are interested in that issue, Justice Kagan has a really powerful, really, really well-written dissent in that case that talks about the court is so bad at looking at like the actual human impact of these decisions. It's really easy to take a 30,000-foot view, and then just what Justice Kagan says, if you're showing up to your local legislators to petition the government to say like I need this, a land variance or whatever it is that you go to your local government to ask for. And you have the court will say, if you don't want to pray, like just don't pray. And everyone is standing up to pray in the name of Jesus Christ, and you have the decision. Okay, I'm about to ask these people for a favor. Am I really going to leave the room? And am I just going to sit there? And so she talks about the real human impact and talks about how like the whole point of our system is that. Who your religious beliefs should not matter in your role as a citizen, and so, yeah, it's a really. Hopefully that she will, sometimes things that are in the minority become in the majority, and as we have seen, in 10 or 20 or 50 years. So maybe one day that will be the standard.
We do have to stop there.
Okay.
Liz, thank you so much. Really appreciate it.
Sure.
And thank you all for being here. I hope you'll stick around and join us for worship as you wish at 11 a.m. And do come back for the forum next week. We will be welcoming our own Stephanie Spellers and Zach Niane to talk about an Episcopal gathering that's happening in Baltimore this week. See you then.